Well, soon, Derek Chauvin's fate will be in the hands of the jury that just sat through 3 weeks of testimony. Closing arguments are set for Monday morning. Yesterday, the prosecution called only one rebuttal witness, and Derek Chauvin declined to testify in his own defense. So I want to bring in Rebecca Roiphe to break all of this down for us. She is a CBS News legal contributor and a professor at New York Law School. Rebecca, thanks for joining us this morning. What should we expect from the closing arguments on Monday? What points will each side need to hit?
Yeah, so we've been hearing very different narratives from the defense and the prosecution, and now they have their shot at telling their story in a more coherent way. So I think the prosecution is going to focus on the fact, try to argue that Chauvin used unreasonable and life-threatening force as he kneeled on the neck of George Floyd for those long 9.5 minutes as bystanders were begging and pleading with him to help. And the defense, to the contrary, is going to say that, this was a tragedy in which George Floyd died of sudden cardiac arrhythmia due to his heart condition and his drug use, and that the use of force was ugly but appropriate, and especially given the fact that there was this, crowd of bystanders heckling and giving the officers a very hard time. So these are two different stories. Each side is going to try to convince the jury, and remember that the prosecution has the burden of proof.
One of the things that's sort of interesting to me, Rebecca, is the jury is going to be sequestered while they deliberate. Why are they doing that, given that they haven't been sequestered throughout the entirety of the trial, and there's been a lot going on, as you know?
Right. I mean, this is extremely rare, sequestering the jury for the course of the trial, and then maybe a little less rare to sequester the jury during deliberations. The idea is, in this particular case, it is so high profile, the coverage is so ubiquitous that it would just be kind of impossible for the jury to ignore all of this commentary. And so, I think they're hoping that the decision won't take, an extremely long time, but regardless, they're trying to keep the jury away from the influences that would be basically impossible to ignore.
The prosecution asked the judge yesterday if they could introduce new test results that show George Floyd's carbon monoxide levels. They wanted to ask their expert witness about it after the defense expert testified that exhaust from the nearby police cruiser could have contributed to Floyd's death. I want to play some of what the judge had to say.
So Dr. Tobin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple.
So why would presenting this information possibly cause a mistrial? And do you agree with the judge's decision?
Yes, I think the judge made the right call here. The prosecution had advance notice that the defense was going to argue that one of the possible causes of George Floyd's death was carbon monoxide poisoning, and didn't find those test results until after the defense had presented this. So if they had presented the test results after the defense, suggested that carbon monoxide might be part of it, it would have made the defense look as if they were lying or being disingenuous or just incompetent, and that really could prejudice the jury against the whole argument that the defense makes. So, the judge still allowed the pulmonologist expert for the government to testify, and he was allowed to testify as to the positioning of George Floyd's head in relationship to that tailgate, the position of the car, whether the car was even on or off, and the other tests that the defense did have access to that themselves seemed to somewhat undermine the argument that carbon monoxide could have been even a factor in the cause of death.
The prosecution, Rebecca, also put Dr. Martin Tobin, a pulmonologist, back on the stand yesterday to counter the defense's claim that carbon monoxide could have contributed to Floyd's death. Let me play some of that exchange with the prosecutor, where he takes issue with the defense witness theory.
The maximum amount is 2%. It doesn't even tell you that it is 2%. It could be something else. But 2% of carboxyhemoglobin is within the normal range. You and I have levels of carboxyhemoglobin of somewhere between 0 and 3.
As to the statement that his carboxyhemoglobin could have increased by 10 to 18%, in your view, that's not possible.
It's simply wrong.
And it was at most 2%.
At most 2%.
Normal.
Which is normal.
So, Rebecca, Dr. Chauvin was the only rebuttal witness the prosecution called, and the pool reporter, interesting note, saw all but one juror taking notes on this exchange. How effective was this counter cross-examination?
I think it was very effective. The point here is that the prosecution does not have to prove that the sole cause of George Floyd's death was the neck restraint. They just have to show that it was a substantial cause. And so, I think the defense might have made a bit of a mistake here in trying to suggest that, the carbon monoxide, sort of throwing everything, including the kitchen sink in there, as possible causes of death. And so to the extent that this pulmonologist just made the expert witness look wrong, biased, less competent than the experts for the prosecution, that's a win. Because this is going to come down to whom do the jury believe? Do they believe the experts for the prosecution, or do they believe this expert who testified that the cause of death was undecided? And if they can make that expert, the defense expert, look like he's trying to pull one over on them, then the jury loses confidence in that expert, and the whole case hinges on that. So I do actually think, even though it doesn't really matter whether carbon monoxide was part of the cause of death or not, I do think that cross-examination was pretty effective.
So we also learned that Chauvin would not be taking the stand. He invoked his Fifth Amendment right yesterday. And it was really the first time we in the court heard from him. I want to play some of that sound.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
So the judge is going to tell the jury that Chauvin not testifying in his own defense should not have an impact on their opinion of him or the case. But generally, do juries read anything into that if you're not willing to get up on the stand and defend yourself?
They really shouldn't, because defendants do have a Fifth Amendment privilege against compelled self-incrimination, and there are all sorts of reasons why defendants don't testify on their own behalf. They can be bad witnesses. Cross-examination can make them look, because, old past acts can be dragged up. It can make them look like they're, have bad character, and that can prejudice the jury against them. So there really are all sorts of reasons why defendants don't testify in their own behalf. That said, I do think that juries find it very hard to abide that jury instruction, because the judge is required, if requested, to give that instruction. Do not make any conclusions. Do not draw any inferences from the fact that this defendant didn't testify. But, it's really asking juries to do something that's counter to our moral common sense, which is that when somebody doesn't do it, they kind of tell you they didn't do it. So, I think it's hard, because I do think it's hard for juries, even though they try, to listen to that instruction and really not take it into account.
Rebecca, why didn't we hear more about Chauvin's prior incidents and complaints against him from the prosecution?
Yeah, this is really important, because the rules of the courtroom, it may seem unfair when you're watching it from the outside, but the rules of the courtroom are really designed to make sure that the defense has a fair shot. And that's because, the state is threatening to take away somebody's liberty, and we're a country that values liberty more than anything else. So we have all these safeguards. And one of those safeguards is this rule, which is that, just because somebody has done bad things in the past, that doesn't necessarily mean that they did this bad thing that they're accused of. And again, it's really hard for juries not to draw that inference. Oh, we heard that he's done, that he's had these complaints against him. He probably is a bad guy, and he probably did this. And that's not fair to him, or at least our system views that as unfair. We have to judge the defendant solely on the facts of this case. And so the court will keep out things like that really could prejudice the jury against the defendant. And it's just one of those safeguards. I mean, really, like the privilege we were just discussing, it's one of those safeguards to make sure that we really put the government to its proof, and that it has met its burden when it takes somebody's liberty away, because it is so fundamentally important. We allow more guilty people to go free in this country, just out of concern that one innocent person might go to jail. And so that's why we have all of these rules of evidence.
Rebecca, we thank you very much. Hope you can hear us thanking you. Have a nice weekend. Thank you.